So can I first of all welcome you all to this third of the webinars, or events, I should say, in the Cornerstone Barristers Public Law Week. We've already held 2 webinars. We've got an in-person event tomorrow, I think at 5 o'clock, which has Ruchi Parekh and Jack Parker speaking on judicial review pitfalls and the new procedural rigor. And then we finish off the week with a webinar on Friday with Dean Underwood and Joe Cannon talking about consultation as a public law challenge. Today, you've got the duty of candour and its impact, and today you have the delight, hopefully, of Matt Lewin, and you're going to have to put up with me as well, who's going to start off the first few slides. I should just say, in terms of housekeeping, because we often get asked this, this webinar and indeed the materials will be available on our website, I'm told, probably by the end of the day, but certainly by the end of the week. It should be on our website. And of course, we also have a Cornerstone YouTube account where it will be on as well. So starting off on this subject, and of course, we're looking at the duty of candour and its impact in a judicial review sense. We're going to be looking, as you can see from the agenda, and can I just first of all apologise? You can always tell the slides that are done by me and those that are done by Matt. The ones by me you can probably barely read because they're so small print. The one by Matt is done properly. What we're looking at today is what is the duty of candour, which I'll be addressing. We're looking at when it applies and how it's satisfied with Matt. I'm looking briefly at the question of impact of a breach of duty on the case, and then Matt concludes the webinar with the question of practice points. And what you see in front of you is, first of all, there's a quote from the Administrative Court Judicial Review Guide, which I would hope many of you have access to, not necessarily in hard copy, but online. And that's from section 15 about what it is. It's a special duty which applies to all parties, and parties are obliged to ensure that all relevant information and all material facts are put before the court. And you can see Lord Justice Edis in the HMMA and KH case talking about the importance of it, and it enables the court to adjudicate on issues involving the state, or indeed public authorities generally, without deciding facts or engaging in a disclosure process. And we'll see as we go on with the slides why it's so important. I would say at this early point that when we talk about duty of candour, and we're talking about information being available to the court and to the parties, that includes redactions as well. So what is it? Let's have a look at it in a little bit more detail. First of all, of course, in judicial review, there's no requirement for disclosure, and we'll see the CPR on a future slide, but there's no requirement for disclosure unless there's a court order. And unlike if you were doing, let's say, a trial in the courts, where, of course, you would have statements of case, disclosure, witness statements, etc., there is no such process, and you have the statements of fact and ground with the claim form for the claimant, and you have the summary grounds of opposition, etc. You may, of course, have witness statements as well as the case progresses following permission. It's very much a question emanating from Article 6, and of course the right to a fair hearing. But of course it goes further than that, because it's not just about the right of the parties to know what the relevant facts are. It's about the right of the court, of course, to know that information so that they can make a proper decision based on the true facts. It's more important, of course, when there's less opportunity for a response. So in other words, if one is making an urgent application, and that includes, I hasten to add, something which I haven't done for some time myself, telephone applications. For example, if one has somebody who is homeless and needs accommodation, and there's been a refusal of a section 188, 1 or 3 accommodation by the local authority, you ring up the out-of-hours judge and you talk to them about what the issues are. But of course, it's a way one-sided approach, and therefore it's even more important that you're honest and open and complete in the information you give the out-of-hours judge. It is self-policing, but I'm going to leave that for Matt to deal with. And of course, it is there to ensure that all relevant material and facts are before the court. So in other words, it's not purely about a question of disclosure. It's about information in whatever form being put before the court. And that may, of course, include whatever's in the summary or detailed grounds or the claimant's statements of fact and grounds. And of course, it also applies to things such as alternative remedies. So, for example, if you are saying you want accommodation whilst you pursue your homelessness case, you would obviously be obliged, if the case had gone past the review stage, to advise the court that, of course, there is a remedy under Section 204 for the court, the county court, to determine questions of accommodation pending appeal and the outcome of the appeal. And similarly, you'll be obliged to tell them, if you're arguing about the suitability of accommodation, you'll be obliged to tell the court about the rights to seek a statutory review under Section 202 of the 1996 Housing Act, and ultimately, if necessary, an appeal under Section 204. And of course, the duty is a question of whether it supports or undermines a case. It's not just a one-sided one for obvious reasons. Indeed, in many cases, it's even more important that the court is aware of the negative side of your case, even if you say that ultimately your argument trumps those downsides. Matt will deal with the question of it being a continuing duty. And I've put at the bottom there, and you can probably barely see on the right-hand side of this slide, the two documents. I've shown you the JR guide. And there is, although it's now 13 years old, a Treasurer's Solicitors Department's guide, which is incredibly helpful and a very useful indicator and slightly more detailed version of what you see in Section 15 of the annual JR guide. And it's worth having a look at. I mentioned the civil procedure rules, and when you look at the judicial review part of the civil procedure rules, you can see on the right-hand side of the screen as you look at it, paragraph 10.1 says that in accordance, and this is a relatively recent amendment, in accordance with the duty of candour, the defendant should, in its detailed grounds or evidence, identify any relevant facts and the reasoning underlying the measure in respect of which permission to apply for judicial review has been granted. And I've highlighted 10.2, which is that disclosure is not required unless the court orders otherwise. So if the claimant, or indeed it may be the other way around, if the defendant feels the other party hasn't provided something which should be provided and they don't have it, so they can't provide it, they can ask the court for an order that it's been provided, or that information is provided by the other party in relation to the matter in issue. And you can see again on the left-hand side of your screen, there's references there to the evidence that is before the court in a JR. In other words, you normally don't have much evidence save for the statement of facts and grounds, potentially a witness statement filed with that, summary grounds of opposition by the defendant, and then you, if permission is granted, you would have detailed grounds and then probably witness statements. But again, they have to be sufficient and they have to be accurate and up to date. So that's the civil procedure rules, and it is why, of course, it's very much allied to judicial review because of that 10.2. Disclosure is normally not an automatic requirement. And I've referred a couple of times to the judicial review guide, and if nothing else, if you wanted to have a nice pithy description of what the duty of candour means, you can see that from 15.3.5. The process of preparing statements of case and evidence must be conducted with all the cards face upwards on the table. Public authorities must not be selective in their disclosure, and I just pause there to say the parties must not be selective in their disclosure either, but in particular, of course, in the part of the guide, it's addressing the question of public authority duty. Pleadings and evidence must be drafted in clear, unambiguous language, must not deliberately or unintentionally obscure areas of central relevance, and must not be ambiguous or economical with the truth or contain spin. If, for example, let's say one of the common things you get at the moment is challenges to housing needs assessments or personalised housing plans. If in fact the local authority is carrying out a review of that, you may still have a legitimate claim, of course, but you ought to advise the fact that it was presently under review if you're aware of that fact. And of course, the local authority in their summary grounds and detailed grounds, if permission is granted, should equally advise the court that they are in fact reviewing the HNA or the PHP. Pleadings and evidence must not mislead by omission, for example, by non-disclosure of a material document or fact, or by failing to identify the significance of a document or fact. It's why, particularly in public authorities, one has to be very careful about internal correspondence. I mean, there have been cases where somebody has made a negative comment about the quality of a decision as an internal process, but it's a disclosable matter, and therefore one has to be very careful as to what one says in writing in particular, because it probably is disclosable. Again, I'm afraid one of these slides that is very short, very tight and small, but it's from a case of Bell, Hodge and another and DPP. And it was to do with a process of leading to the DPP's decision to prosecute or not, and it was a JR decision challenging the decision made in those circumstances by the DPP, and it was referring to the fact that there is normally, you would hope, honesty and compliance by the public authority, in this case by the government department, the Foreign Office, Foreign and Commonwealth Office, in disclosing it, but it was a question of whether the documents they had disclosed to the DPP, in order for the DPP to make their decision as to whether to prosecute, should be disclosed as part of the proceedings. And that was to do with the unlawful rendition of the claimant to Libya in that case. And effectively it decided that if clear advice is given on an inadequate basis, or is at odds with the evidence that is before the court, having been available perhaps in privileged material, then there will be a duty requiring the government and indeed public authorities generally to clarify that matter with the court and make it clear to them that they shouldn't be under any misunderstanding as to the position of the government, and more importantly, of course, as to how they reached that conclusion and on what evidence. And so that evidence, if they decide that in fact it's not so great, for example, not only must they then reconsider their decision, but they certainly must make the court alive to that. It also briefly deals with the question of drawing inferences against the party who has breached the duty of candour, and that would apply in cases where you've almost had to tease out the information as well. That may well go against the party who are guilty of that when it comes to any findings of fact in any case. When you look at something like age assessments, and some of you may deal with that, one of the things that those of us who deal with age assessments often are looking for is social media that the young person may have engaged in, whether that's before arriving in the UK or after. And there was a case, you can see there, just by way of an example of the duty of candour, BG and London Borough of Hackney. And I should just pause there to say the duty applies in the upper tribunal as it applies in the administrative court. And of course, age assessments are effectively judicial review in the upper tribunal, where it operates by way of a fact-finding hearing as to age. But you can see there what the duty of candour at paragraph 3 obliges an applicant's legal representative. So we're not talking here about the public authority, i.e. the local authority who made the age assessment. The applicant's legal representative must ascertain what social media and other methods of communication are used by the applicant, consider the relevant accounts with a view to ascertaining whether they contain any material which potentially undermines the case, and disclose any material which might be relevant to the case, including any material adverse to the applicant. And just by way of very quick example, I had a case recently where in an age assessment where the young person's Facebook account had indicated that he may have certainly a relationship with another person, but it turned out from her Facebook account that it was actually a marriage, and he hadn't identified that either with his advisors or indeed with the local authority. And although he tried to discontinue the matter, the court ended up making a finding as to his age. And that's not an uncommon thing. And I'll just refer you to cases such as HB and Derby City Council and LS and Brent London Borough Council, but as similar examples as well. But that's an example of a very proactive thing that a party to these matters has to consider. An example breach you see here had the effect of a set aside of a permission, and we'll see later what the impacts have been, but that's what can happen. And it was quite an astonishing case in that what was known by Mr. Justice Collins on his permission decision was that the person was a national of Pakistan. He'd entered the UK and sought refugee status in 1999. His wife and 3 children were already here and had got refugee status on appeal, and that he was the main financial provider. What he didn't know was that this person wasn't working at all. He'd first entered the UK in 1971, was arrested and deported the following year. He was married in 1985, entered the UK in 1993, was convicted of drug smuggling, released in 1997 and deported, and then re-entered the UK in defiance of the deportation order. And as you can well imagine, there's lots of information there, which obviously was needed in order to be able to make a permission decision. And given that it wasn't before the court, the decision was that the permission would be set aside, and the case ended. Very quickly, extent of duty, I've said already that, of course, well, I'd say of course, it does apply to all parties, and that includes interested parties. And you can see references there. And so even, for example, in a case where maybe the defendant isn't going to play a very active part and is leaving it to a interested party, which sometimes happens in planning cases where the developer may be the interested party and the local authority is not particularly interested in playing an active part, maybe not even putting in summary grounds. The local authority in such a case would still have that duty of candour. And so if they're aware that the court isn't appraised of all the information that they need to be appraised of, they would have an obligation and a duty to make the court aware of that fact. And just by way of example, there was a case of Crown and Mid Counties Limited and Forest of Dean, where Mr. Justice Singh, as he then was, came to that conclusion. Means of compliance, I'm largely going to leave to Matt. So despite the fact I managed to work out how to do arrows, I'm going to leave that to Matt. Lawyer, by the way, was just an ex parte relief case, where, as I said earlier, candour is all the more important. It was by way of a telephone appointment in relation to a emergency accommodation. And lastly, before passing on to Matt, I've just got this quote from Mr. Justice Hodgson, just to say it was highly desirable for counsel and solicitors instructed by an applicant for judicial review to give further careful consideration to the merits of the application once they received notice of the respondent's evidence, even though leave to move for judicial review had already been obtained. If that were done, much time, expense and disappointment involved in the hearing of hopeless applications would be saved. In other words, it is ongoing, and the fact that you've got permission, even if you've got permission on a proper basis with the proper information, if things change, you may have to look at that and say, well, we weren't aware of that, but now we are aware of that. Either we can still proceed, or we can still proceed with information that needs to be provided, or that we can't proceed. But it's an ongoing obligation. So I'm going to pause there, and I'm going to pass over to Matt, who will be dealing with when the duty applies and how it's satisfied.
Thank you very much, Andy. So as Andy has just told us, essentially the duty of candour is about integrity, and certainly from a public law perspective, upholding the rule of law. It's about not seeking to win the case at all costs, but making sure that the court makes the right decision for the right reasons. So when does it apply? Well, the bubble on the screen is an extract from the Treasury Solicitor's Guidance, which Andy's already mentioned. It's an old document, 2010, but we were just talking before the session that more or less everything it says, notwithstanding 13 years of case law subsequently, still holds good. And in terms of when the duty applies, one thing the guidance says is it refers to the department becoming aware that someone is likely to test a decision or an action affecting them. And this extract was explicitly quoted in the case of HM, which Andy's also mentioned, had a quote on the very first slide, and saying that this essentially represents the law. Now, importantly, what the guidance doesn't say is the duty of candour applies as soon as you receive a pre-action protocol letter. It refers to becoming aware that the decision is likely to be challenged in court. So that might be on receipt of a pre-action protocol letter, but it could, for instance, be earlier than that. For instance, where the decision is highly controversial and where you've got solicitors acting for interested parties snapping at your heels before the decision's even been made. In those kinds of cases, it would be sensible, I think, to act on the assumption that a challenge will be made and to prepare accordingly in terms of thinking about how we comply with the duty of candour, preserving documents, advising clients, all things that I'll come on to in a moment. Even if it turns out in the end that the challenge isn't issued, I think that's a good piece of practical advice. The duty, of course, is a continuing one, and the Treasury Solicitor's guidance continues to say that the duty of candour applies throughout the proceedings. For example, if after the service of evidence, further relevant information comes to light, that information must be disclosed to the other parties and put before the court at the earliest possible opportunity. And in practice, what that means is that the duty needs to be considered at every stage of the proceedings. So that's from your letter of response at the pre-action stage, your summary grounds, detailed grounds, any witness statements, and of course, the written and oral submissions that you instruct Andy and myself and our colleagues at Cornerstone to make on your client's behalf. And it's very, very important that you bear in mind that the case will evolve, and that may impinge on the kind of documents that need to be disclosed or the kind of information that should be disclosed under the duty of candour. And that carries on right until the very conclusion of the proceedings. So with that in mind, when the duty applies, let's think now about how to satisfy it. Now, I think in many cases that we deal with, actually the duty of candour is probably unlikely to play a significant role in how you prepare and how you conduct the litigation. In many cases, the necessary documents are already in the public domain, or they might already be in the party's possession, depending on the nature of the case. But even in those kinds of cases, I wouldn't recommend being complacent about the duty of candour, not least because, as we'll see, the consequences of getting it wrong can be very serious indeed, not only for your client's interest, but potentially you personally as a professional. So it's important to get it right, and I'm sure everyone knows that. So from my perspective, compliance with the duty is, or certainly should be, a team effort. Within that team, you need a captain. And for me, that's someone who's got overall responsibility for ensuring that the disclosure exercise carried out complies with the duty of candour. Now, that will usually be the solicitor with conduct of the case. And in any case, it should be someone with appropriate seniority and experience, someone who knows, has a track record in handling these kinds of cases and understands the duty of candour requirements. Now, that person is responsible for deciding, for instance, which documents are relevant and disclosable under the duty, advising their client departments about the existence of the duty and what it requires, including, importantly, the need to preserve potentially relevant documents. So, for instance, if there's a scheduled deletion or destruction, that might need to be put on pause just while the documents are gathered to prepare for the litigation. Maintaining a record of what searches have been carried out, liaising with counsel on issues of disclosure, and ultimately, if required, being able to explain and justify what disclosure has been given under the duty of candour. But as I said, it doesn't all fall to the solicitor with conduct. It's a team effort, and therefore the client department will also play a very important role in this process. It's really important that the client, and by the client, I mean everybody working within the department who has a potential involvement in the case, either as a decision maker, someone who contributed to the decision, or someone who's involved in giving instructions to how the litigation is handled. All of those people need to understand the requirements of the duty of candour and the consequences of breaching it. And so there should ideally be a single point of contact within the client department for the solicitor with conduct to liaise with, and that person should be able to explain to the solicitor how information is stored within the department, where it can be found, what kind of information is out there, and should also be responsible for supervising searches within the department for information that could be disclosed under the duty of candour. But my strong recommendation would be the client provides everything to the solicitor, and the solicitor then reviews for relevance. It shouldn't be solely down to the client to make that call on relevance. Counsel, of course, plays a very important role in this process too. We can be relied to advise not only on specific issues of disclosure, i.e., is this particular document or is this particular part of a document disclosable under the duty, but also more generally on how the litigation is evolving and what the issues the court needs to decide are, because the issues in the litigation will obviously affect the nature of the duty and how much information needs to be disclosed under it. Andy mentioned the importance of not only, in terms of how you present documents under the duty of candour, you'll see references in the cases to it not being sufficient simply to do a big document dump. So it's compliance with the duty of candour does not involve simply putting a relevant and unhelpful or unflattering document in the bundle. It requires you to go a lot further than that. It requires you to highlight specifically the significance of that document to the court and to explain in outline why it's significant to the issues for the court to decide. Okay, so one other point I wanted to make is about maintaining a record of how the disclosure exercise has been carried out. I would say this is good practice, and in cases where compliance with the duty could become contentious, absolutely essential. And the Treasury Solicitor's guidance on this point rather sweetly observes, I think, that an inability to explain how a muddle has arisen can be worse than the muddle itself. Very, very true. Good advice, I think. Where a mistake has been made, the best course of action is always to be open and apologetic about it, acting as soon as possible after the mistake comes to light. And I will come back to that when I return to talk about practice points in a moment. Now, what should that record include? Obviously, it needs to include what locations were considered for searching, what searches were carried out. Just waiting for the second bubble to appear. Thank you, Andy. What decisions were made about disclosability, so decisions to disclose, not to disclose, and how documents were prepared for disclosure, particularly where documents are going to be partly redacted for sensitivity reasons, privilege reasons, perhaps even in a very serious case, public interest immunity reasons. So that needs to be some kind of record of how that process was decided also needs to be included. It may, separately to this, may also be helpful to keep a record of what documents have been seen by different members of the team, particularly counsel, where we're external to your organisation, and there's the possibility for miscommunication crossed wires, which was a problem in the HM case, which I'll come back to. And often you can rely on counsel to identify a list of documents that they've come across in their preparation for the case that they haven't seen, and then hopefully a request with a nice neat list. Here are the documents I need to see, please send them back by return, that kind of thing. Now, the reason why keeping a good record to show how the duty of candour has been complied with is because hopefully in rare cases the court could start asking questions about how you've gone about compliance, and you might find yourself in the very uncomfortable position of having to justify your actions to an angry judge. But as I said, I will come back to that topic when Andy hands back to me, so I'll hand over to him now. Thanks very much.
Thank you very much, Matt. And as you say, I've got responsibility for moving these things on, and not always 100% successfully. My part is impact of breach of duty. I should just say before dealing with this comparatively brief part, that there are some questions already raised in the Q&A section. We're not ignoring them. We have got time at the end for questions, so we'll address them then. So please don't feel we're ignoring them. So what is the impact on a case? It's all very well saying, well, look, it's fairly obvious that you need to be honest, you need to be open, you need to be thorough, you need to be continuous in your rigor. But what's the impact if, for whatever reason, and it may be not the solicitor's fault, not counsel's fault, you know, you can only do what you're told in some instances. It may be the client's fault. It may just be that something new has happened and that therefore that it has to be passed on. What is the impact of that failure and that breach? Well, one of the impacts, and this is what this slide deals with, is the adverse inference of fact, which you saw in the case of Dasson, the Secretary of State for the Home Department in 2014. You can see there that Ms. Anderson submitted no obligation to file witness evidence in relation to whether or not there is an entitlement to compensatory or nominal damages, and the question is a matter for the court to assess. She urged the court not to punish the Secretary of State for not filing evidence and referred to the scarcity of resources, the heavy litigation burden, and the need to prioritise resources. And was trying to obviously explain why information hadn't been put before the court. And then ends up by saying there is equally no question of the court punishing the Secretary of State or treating her less favourably than other litigants. And then what was importantly concluded by Lord Justice Beatson was that where a Secretary of State fails to put before the court a witness statement to explain the decision-making process and the reasoning underlying a decision, they take a substantial risk. In general litigation, where a party elects not to call available witnesses to give evidence on a relevant matter, the court may draw inferences of fact against that party. The basis for drawing adverse inferences of fact against the Secretary of State in JR proceedings will be particularly strong because in such proceedings, the Secretary of State is subject to the stringent and well-known obligation owed to the court by a public authority facing a challenge to its decision. That's the duty of candour, of course. So that is one of the risks, is that in terms of what the court finds, if you don't put evidence forward or if you put inadequate evidence forward, the case, which may not otherwise be a very strong case, may suddenly be improved at the expense of the defendant public authority. There are certain other implications, of course. We've already seen the example of a permission being set aside in the Khan and Secretary of State for the Home Department case. You could, of course, not get permission at all because of that failure to exercise the duty of candour. And again, I would stress, in a lot of these cases, it's not necessarily the lawyers that are being criticised. It's just a matter of fact that information hasn't been put before the court. Sometimes it is the lawyers not being thorough enough, but it's rarely the case that somebody has deliberately concealed matters. It's normally the case that things which perhaps should have been explained or should have been put forward have simply not been done so for a variety of reasons, resources, time, or just a pure oversight. But it doesn't get away from the fact that there is still a breach of that duty. And as you see, permission can be refused. You may have a discharge of an injunction. You know, I gave you the example of an out of hours application that some of us used to do a lot of in the early days, and maybe somebody got accommodation by reason of that. If, however, it later transpires that in fact they can stay on a friend's sofa or whatever, if they're a single person, and that's not the end of the world, then maybe that's something that should have been put to the judge and that they're not in fact street homeless, and therefore that could affect the question of whether the injunction should stay in place. And it will have an impact on that alongside, of course, what the law is on the question of interim accommodation in such a case. Of course, if it's a problem that actually has been committed by the solicitor or the barrister or other lawyer, then of course it may go to their regulatory authorities if there's been deliberate concealment in such cases. And that has happened, regrettably, on occasions, but isn't a common matter. And of course, as you might imagine, one of the obvious areas where this may come up is on the question of costs, not just in the question of the public authority or indeed the claimant having to pay the costs, but maybe wasted costs, particularly in the case of a claimant, for example, who may otherwise be legally aided. And if it's down to the fault of the solicitors, for example, or counsel, then it may be that wasted costs are appropriate in such cases in the normal way. So it's not one of those duties that is, in a sense, more honoured in the breach. It's one of those duties that is treated extremely seriously by the court. And in essence, of course, what is being said is that the court simply cannot operate if, in fact, people aren't putting forward the honest case at every step of the way. And as Matt has said, that means from pre-action right through to conclusion. If the court isn't appraised of the proper information, they can't deal with judicial review in the way that it should be dealt with, and therefore the decisions that have been made in absence of that information have to be readdressed and maybe in appropriate instances set aside, even if otherwise they may have been successful. I'm now moving on to the final section before we get to the question and answer session, which is the question of practice points. So over to you, Matt.
Well, thank you very much again, Andy. So having looked at some of the recent cases which have prominently featured the duty of candour, it seemed to me that there were a number of helpful practice points that I thought would be helpful to share with you in this session. So the first one that struck me as interesting is that the court will work on the assumption that the duty has been complied with. Now, a good example of a recent case where that's really explicitly stated is a case called Solier. I'm not quite sure, it sounds like it might be a Channel Islands name, Solier versus South Cambridgeshire DC from earlier this year. It was a planning case in which one of the issues raised in the claim was an allegation, as you often see in planning cases, that the planning committee of South Cambs District Council had been materially misled by advice in the planning officer's report. And the case was heard by none other than Mr. Justice Fordham, who some of you will know, and some of you might have spotted in an earlier slide of Andy's, is the author of the Judicial Review Handbook, essentially the Judicial Review Encyclopedia. And in stating this important principle, he very kindly name-checked a dear colleague of ours. He said this: "It's also relevant that the local authority appears in these proceedings with a duty of candour and, I emphasise this bit, if there were material in the possession of the local authority to support the conclusion that it had been materially misled, I would expect it to be brought to the court's attention." Mr. Beglin for the local authority has very properly confirmed that from his client's perspective, the duty of candour is regarded as being applicable at this permission stage. In other words, what we can see happening here is that the court is willing to extend a considerable amount of trust to public authorities involved in judicial review litigation, that the duty of candour has been complied with as a matter of routine and that it doesn't require any further scrutiny or assurance. So I guess the point is that trust has been hard earned and shouldn't be abused. But the second point that really follows on from that first point is that where issues about compliance with the duty of candour are in dispute, the court will generally need some positive evidence to suggest that the duty of candour has not been complied with before it will consider whether further disclosure is required. I think there's another bubble there, Andy, if you wouldn't mind popping that up on the screen. There we go. Positive evidence required to rebut. Now, the case of Gardner versus Secretary of State for Health and Social Care, a case from 2021, is interesting on this point. Well, the underlying claim was a challenge by a number of bereaved family members who'd lost mostly elderly relatives in the very, very early stages of the pandemic, when the hospitals were cleared of beds and sick people sent back to care homes infected with COVID. And the particular issue in this case was an application by the claimants for specific disclosure, and they made a number of very, very wide-ranging requests, and that application was eventually dismissed by the court. And the court said this: "At this stage, however, it has not been demonstrated that the defendant's witness statements serve to obscure areas of central relevance, and the criticism made presupposes an obligation to provide disclosure of documentation akin to a contested trial on the evidence rather than a judicial review." I think that encapsulates a number of points that we've made earlier in this session. Obviously, that there's no standard disclosure in judicial review proceedings, but more importantly, that there was nothing in this case to suggest that the Secretary of State for Health had not complied with the duty of candour. They'd actually provided some 5,000 pages of disclosure, And you note the point about the witness statements not obscuring areas of central relevance. In other words, they'd been upfront about the issues, even potentially unflattering issues that affected their case. The third point comes back to the importance of maintaining a proper record of how the duty of candour has been complied with. So remember, that's about what searches were carried out, what information was and was not chosen for disclosure, etc. And as I've said, in a typical case, the court will work on the assumption that the duty has been complied with and that there's no need to go behind a public authority's assurance, even if an assurance is required. And as I say, in most cases, it probably won't be that is the case. But as the upper tribunal said in the BG age assessment case that Andy extracted from the judgment on an earlier slide, it is largely a self-policing duty. And every so often, the court is asked to actively police compliance with the duty. The case of Gardner was an example of that. And indeed, in that case, as I said, the court declined to order specific disclosure, but it did direct the Secretary of State to file a disclosure statement to provide greater clarity as to the approach they'd taken in relation to disclosure of potentially relevant WhatsApp messages between members of the government and advisors to the government that might potentially be disclosable under the duty of candour. The Department of Health had been quite open in their witness statements that they were still reviewing those messages, and the process of deciding what or what not to disclose from that enormous treasure trove of information was still ongoing. And in those circumstances where there was a little bit of uncertainty about what decisions had been made, the court ordered a disclosure statement. In other words, something that looked very much like a good written record of how the duty had been complied with. Now, this was something that was also ordered in the BG case, the age assessment case that Andy's mentioned. And the upper tribunal said that in that case, and probably generally, a disclosure statement serves a number of purposes, and those would include ensuring, from the court's perspective, and I guess the other party's perspective as well, that a proper process has been undertaken, and also providing assurance from an officer of the court that all relevant material has been disclosed. And the tribunal noted that where there is an application for specific disclosure, the provision of a statement like that is a strong factor weighing against granting specific disclosure in a case. So clearly, in order to prepare a disclosure statement, whether that's one that's been ordered by the court or that you've decided out of an abundance of caution to do voluntarily, and in one of the defendants in the Gardner claim did just that, a proper record of the disclosure process is obviously essential. And that's, I think, a powerful reason for carefully recording how you go about it at the time. Now, the fourth and final point, which I think hopefully touches on one of Judith's questions. Judith asked a question, where you suspect that information or documents haven't been disclosed, how can you remedy that situation? So the fourth practice point I wanted to touch on was how to respond when it becomes clear that the duty's not been complied with. And I think this is very well illustrated by the recent case of HM versus Secretary of State for the Home Department, which I alluded to earlier as a catastrophic failure of compliance with the duty of candour, and it involved a breach that I think, as a lawyer who gets involved in cases a little bit like that, would make your blood run cold. Now, in this case, this was a challenge to an alleged policy that the Secretary of State, the Home Secretary, was operating a couple of years ago, of routinely seizing all mobile phones found on people arriving on small boats on the coast. Now, the Secretary of State, in her pre-action response and in summary grounds, had robustly denied the existence of that policy. Now, unfortunately for them, it turned out not only did that policy exist, but it was also unlawful. And the court ordered that a separate hearing be carried out in order to establish the facts behind the serious breach of the duty of candour and to decide what consequences should follow. Now, interestingly, the main problem from the court's perspective was what they described as the very robust, or to paraphrase, very robust denial of the existence of this policy. What the lawyers knew was that a blanket policy along these lines had existed, but they were under the mistaken impression that it had been ended, or rather the policy had been amended in June 2020. Now, they were aware that a blanket policy was unlawful, but because they took the view that the policy had been amended before the claimant in this case had their mobile phone seized, they didn't need to refer explicitly to the existence of this earlier policy. And the court was critical of that judgment call. They said that had the lawyers been more open about the earlier existence of this unlawful policy, it's possible that the assertion would have been investigated, and the misunderstanding that they were labouring under in denying the existence of this policy could have been corrected earlier. So the government legal department's response in this very unfortunate situation was, I think, probably a textbook example of how to respond when the S hits the F. Now, as soon as the lawyers acting for the Home Secretary realised that they had, in good faith, due to inadequate instructions from the client department, misled the court, the error was promptly corrected, firstly in correspondence to the court and then subsequently in detailed grounds. And the court expressed in its judgment its gratitude for what it described as the frankness and candour with which those errors were corrected, as well as the, quote, unreserved apology, you'd expect nothing less, provided by the Home Secretary. Now, what the GLD did was they commissioned a senior lawyer within GLD to carry out a full review. That lawyer then provided a witness statement setting out exactly what they'd been able to discover about how the error had happened. In doing that, the Home Secretary, very unusually, gave a far-reaching waiver of legal professional privilege in order to disclose documents, including notes of conferences with counsel, emails between counsel and instructing solicitors, etc., to explain again how the error had come about. And also, very uncomfortably from mine and Andy's perspective, a witness statement from counsel who had drafted the inadvertently misleading documents. I think the key lesson really to take away from that case is where there has been a mistake, and mistakes certainly do happen, fess up early and be as transparent about it as possible. And that way, I think you're probably likely to limit the damage. And indeed in HM, that was a serious case of a breach of the duty of candour, but the court, I think, was quite lenient in terms of not naming and shaming any individuals involved and recognising that, as I said, compliance with the duty is a team effort. And on this occasion, the team collectively didn't come up to scratch. So that's all I've got to say on practice points. We'll move, I think, to questions and answers. Thanks for your questions that have come in first. Andy, do you want to...
Yes, I mean, you've obviously addressed some of what Judith has said already. There's an anonymous attendee who's asked about if a local authority fails to offer a satisfactory response to a pre-action protocol letter. Pause there to say sometimes, of course, there's no response at all, let alone an unsatisfactory one. Is the onus on the complainant to take the matter forward within 3 months? Well, obviously, the judicial review time limits and the question of promptness, and one of my bugbears is people talk about things like 3 months and so on, and putting aside planning, different time limits. 3 months is a bad way of looking at a time limit. It's about promptness. But you equally are required to, in most instances, of course, unless there really is a problem of time, go through the pre-action process. But you shouldn't be using a failure by the public authority to respond or respond adequately as a reason for delay. In other words, as long as you've acted in a proper fashion, you've set out your client's case in a proper manner, accepting, limitations on what the local authority can be expected to do, but you have got no response to that or no adequate response to that, there comes a point at which, of course, you can't be expected to go backwards and forwards in correspondence to get a complete response. Having said that, of course, if you get a very good response from the public authority from a pre-action correspondence, which requires you to, in a way, think again, or maybe raises information which you haven't been able to take instructions yet from your client, that may be a reason for delaying issuing the claim, because, of course, when you do issue, you want to have it with the full facts available. And if something's been alleged by the potential defendant authority, then, of course, you want to be able to meet that if there is sufficient information to do so. So that's what I would say to that query. There's another one, Matt, I think, the 1051.
Thanks, Andy. I just wanted to add to your answer. I obviously totally agree with what you've said. I think if you don't get a satisfactory response to a pre-action protocol letter, for instance, if there is, well, let's imagine a situation where you get a pretty kind of generic high-level response at pre-action stage, and then something quite different emerges in summary grounds of defence. That obviously puts the local authority or any public or defendant public authority at serious risk of a pretty nasty costs order. That obviously adverse information disclosable under the duty of candour should have been disclosed at the pre-action stage. As we know, it applies from the very earliest stage of the proceedings, and that might be a situation where we're looking at potentially indemnity costs, or perhaps even worse, depending on how serious the breach is. In response to the question we've had from our anonymous attendee at 1050, the question is, we often get asked to disclose the client file throughout the pre-litigation stage and after permission by the other side pursuant to the duty of candour. How should we respond? Well, it will obviously depend on exactly what the issues in the case are and what's contained in the client file, but that to me sounds like more of a fishing request than a specific request under the duty of candour. One thing that the upper tribunal said in the BG age assessment case is that if you're kind of laying the groundwork for a request for something specific, perhaps even a request for a formal application for specific disclosure, in some ways you need a target. So those kinds of blanket requests probably not required to comply in full, because there's going to be, I imagine, a fair amount of irrelevant and certainly potentially privileged information within the client file. But you obviously need to consider those questions carefully in case there is material that is required to be disclosed under the duty.
I mean, there may be, of course, a DPA obligation. That's the Data Protection Act.
Yes.
But you're absolutely right, Matt. I mean, I think people generally get that wrong with disclosure, even outside judicial review, where they say we want the housing file, for example. And most of that, for example, if you're doing an antisocial behaviour case and your housing file has lots of rent arrears information, well, it's irrelevant to the antisocial behaviour case. But you may be entitled to it under the Data Protection Act, but you're not entitled to it under the disclosure provisions. And in a way, duty of candour is disclosure, although it's more than documents, of course, as we both have said in previous presentations. So it is right to say that they are different, and what you're trying to do is to make sure that what you give is relevant. Having said that, there are some cases where it's easier to give over, for example, a housing file, but I would caution to say that that may not be sufficient. So, for example, there may have been engagement with other departments. There may have been engagement with third parties, and maybe that information needs to be dealt with, whether that's, I don't know, children's services or social services or environmental health, or even, as I say, third parties, like the health service and so on. If you're a local authority, there may be those which you need to perhaps look outside the file. So don't be beguiled into thinking we've got the housing file, I've obviously complied with my duty of candour. Matt, there's a request for cases that you cited.
So I've hopefully put that, I might have run out slightly of word limit, but hopefully that's gone through.
Oh, right, lovely, well done.
Yep. Well, we can add that to the material that goes on the website as well, no problem. Judith's question, are there any signs or signals that can be indicative of failures to disclose to tell you that you may need to ask for further details? If memory serves, in relation to a criminal law case, for example, there was a case about an Oxford Circus protester where video footage that showed they were innocent may not have been disclosed. Shall we say as early as it should have been?
I suppose in a case like that, I mean, in a sense, you're saying, well, why isn't there this, which you might expect? So, for example, when you're in the public arena, one might think about cameras and so on, and is there anything like that? And we know that there was a camera on that lamppost. But generally speaking, it's either going to be information that your client says that they've given to the other party, and yet there doesn't seem to have been any record on that, on what you've got from them, or there doesn't seem to be any reference to that in, for example, their grounds to the fact that you did communicate with them, and that may indicate a gap in what they've done. And remember, we're not just talking about disclosure; it's about information generally. So where your client has given you the version of events enabled to defend or prosecute a JR, in those circumstances, I think you would be expecting the other side to meet it precisely, and each and every point to be met. And if it's not, you can't. But I think, Judith, in terms of a more broad, we don't know what we don't know kind of problem, it's a difficult one, and I do appreciate that.
Well, from my perspective, and just thinking about if you look at the judgment in the HM case, where the Home Secretary had to disclose a lot of privileged information, one of the warning signs might be, and I have to say I've been in this situation once or twice, is draft documents with lots of comments on the side, kind of going caveating this or qualifying this, or can you confirm that that I've got this correct, and then silence from the client. That was, I think, where the lawyer, the GLD and counsel acting for the Home Secretary went wrong there, is that they were asking for confirmation, clarification, correction from their client, and they weren't getting anything back. So I think silence from the client, where the lawyers are uncertain about exactly what the factual basis is or the policy basis is for defending or even bringing the claim potentially, but certainly from a public authority perspective for defending the decision or the policy, where those questions are not getting answered and we're getting closer and closer and closer to filing the document, I think that's probably a big red flag, where someone needs to go and bang a few heads together in the client department.
By the way, I should say there's no problem with people being anonymous. It wasn't a negative comment. I'm quite happy for people to be anonymous. There is a question I don't necessarily know the answer to, where a penalty charge notice has been issued by a local authority and contested in a traffic penalty tribunal, and the appeal is refused. Is it appropriate for a JR to be sought of the local authority? Should the appellant seek a JR of the tribunal? Well, I think, firstly, obviously that's a very fact-specific query, and I think you might wish to have a chat with the clerks here if you want any instructions on that. But I think generally it is JR is obviously there to challenge the decisions of public authorities or those exercising public functions. And so it'd be a question of which it is. But of course, the difficulty you would immediately face is that you've already had an alternative remedy. In other words, you've exercised your right to go to a tribunal, and that tribunal has not, which I know nothing about, I hasten to add, and that tribunal has not found in your favour. So it's difficult to see why you would go against the local authority unless you've discovered some ex post facto information in respect to the local authority, maybe demonstrating bad faith or whatever. Although even that would tend to be a remedy that you'd take back to the tribunal. In terms of taking the tribunal to JR, I mean, in principle, I suppose. What do you think, Matt? I mean, I don't
know. It sort of strays off topic a little bit, doesn't it? But I probably don't have much more to add.
Yeah,
what you're saying.
I mean, but as I say, I think in terms of the duty of candour answer, if it is because of information that you've discovered that wasn't put before the tribunal, the remedy is normally to go back to the tribunal and set aside the appeal. And you saw the remedies that we talked about within the more mainstream administrative court processes, and there's no reason why that wouldn't operate in the tribunal setting as well.
Yeah, we've got one last question, I think. We just hit 11 o'clock. How broad can disclosure be? Does it need to be specific? My short answer to that would be it needs to be tied to what issues are in the case, and you can look to counsel, I think, to advise you on that to the extent that there's any uncertainty about it. So it comes back to that question, I think, about do we have to disclose the client file? Possibly, but probably not everything. I think you're entitled to go through it and make an assessment, or your solicitor with conduct in the case, taking advice from counsel, can make that assessment about what's relevant and therefore what needs to be disclosed. Andy, anything to add to that?
No, not really. I mean, I think it is, in terms of caution, it's always best to be kind of on the safe side.
Yeah.
But equally, you're entitled to deal with the matters as set out by the other side. Having said that, if they have missed something, but it is potentially relevant, whether that's in your favour or not, we go back to the fact that, of course, you're obliged to either provide the information about it or provide the disclosure, depending upon what it is.
Absolutely. Yes. Even if that potentially exposes you to another ground of challenge or makes the claim totally indefensible.
And it is frustrating because sometimes you're almost improving what are maybe poor grounds. You're effectively saying, well, that's not really a good case, but
Yeah.
we do accept that we haven't done this.
Yeah.
But I mean, I'm afraid that's the nature of a public function, isn't it, really, that it's there to be challenged, and remedies might be in cost or whatever, but there we are.
Yeah.
Look, can I just thank everyone? I mean, amazingly, I think it's one of the first sessions I've ever done where we actually finished our session at 45 minutes and we had 15 minutes of questions, which, given that it's never happened to me, obviously means the problem's me. So thank you so much for everyone who's attended this session. Please, as I say, look out for not only this webinar and the notes to it and the PowerPoints to it, I should say, but also the others of the Public Law Week, which have happened already on Monday and Tuesday and are happening again on Friday if you're not able to make tomorrow's event in person. And as I say, I hope you have a great day and hope to see you soon, either on a webinar or in person. All the very best.